Mr. Fogarty?
Good morning. Why did you put the one I'm recused on right?
Good morning,
Your Honors. My name is Edward Fogarty. I'm an attorney who practices in Springfield, Massachusetts, and it is an honor to be here. I represent Mr. Connors, as you know, who was a respondent or defendant in a matter of a Mass General Laws 123A, Section 12 trial in Middlesex County, and he was adjudicated to be a sexually dangerous person. I have raised two issues on appeal, one having to do with hearsay evidence, I would suggest, contained within a minimus, which was allowed into evidence over objection of counsel. And the second issue is whether Mr. Connors would have a right to present evidence of his examiner having interviewed him in evidence while having refused to interview with the qualified examiners on behalf of the state. And the judge, over objection, denied Mr. Connors' opportunity to present his examiner, and it went to trial with the opinions of two qualified examiners who rendered their opinions absent any interview of Mr. Connors. I will address the issues in order, the first issue being that of the hearsay question within the minimus. As this Court, of course, well knows,
Can I ask you a question about
Yes, sir.
the minimus, and I'll ask the Assistant District Attorney the same thing. I don't understand where this description comes from, circumstances of offense. There's some suggestion it's a transcript of the court proceedings. It certainly doesn't look like a transcript of anything that I'm aware of.
And I, of course, would agree with Your Honor. As I understand the statute for a minimus, it is a statute that calls for the transfer of the individual with paperwork from the court describing the sentence and that information for the holding facility, as it were. On this particular minimus, which was from a juvenile court, I believe, it is nothing more, I would suggest, than a note. It is somebody placed a notation on that piece of paper describing that Mr. Connors had been, I defer to the record, I think it's either been convicted or, yeah, he was convicted of having had some sexual charges involving two young boys. And then in the second paragraph, it references that police also report that he, at some unspecified time, had digitally raped, I believe.
Well, a minimus is an order to take someone somewhere. Is that not correct?
That's correct.
And does the minimus ordinarily have anything more than that on it?
I would suggest ordinarily not. May it sometimes, in the practice, as I understand it, within the trial courts, yes, it may sometimes contain, frankly, irrelevant information. I suppose the Commonwealth would cite cases, and they have in their brief, where minimuses may be amended to correct sentences and contain other information relevant to the sentence that has been imposed. But this has nothing to do with the sentence. This merely has to do with, I gather, somebody's note as to what he was sentenced for.
So I take it that you don't know, for example, whether this minimus, whether these offenses that are described here, leaving aside the one that was not charged, are really the result of a plea in which the police report was read?
Well, I believe, no, Your Honor, I believe the first paragraph in the minimus, that having to do with the two young boys, was established at trial as having been, I believe it was the result of a plea in the juvenile court. I'm quite certain that's the case. However, the second reference to uncharged conduct,
it was a plea or a trial?
I believe it was a plea.
Okay.
To the second reference, there is no support within either the QE reports at trial, nor is there any evidence introduced at trial, and nor certainly is there any corroboration in any record that I know of that was introduced to evidence. There's merely just this reference. And I would suggest
Again,
that-
we're not talking about a trial here, right?
Well,
correct.
except, Mr. Fogarty, the Commonwealth, I mean, you know, quoting from the statute, 279, Section 34, said a minimus is a duly certified transcript from the minutes of the court of the conviction. I didn't see any duly certified. Was it?
Sorry?
I didn't. Was this certified before it was admitted in evidence? I mean,
I'm not
Well-
certain. I'm not certain, Your Honor. Whether it was certified or not, I'm not certain.
Okay. We'll ask the district attorney's office about that.
But in any event, with regard to that particular reference within the minimus, I would suggest that it goes beyond the pale of any hearsay rulings that this court has issued in its various cases that does allow in hearsay. This is not admissible, as far as I know, under any exception to the hearsay rule. The statute that allows in so many records in these cases, which is 14C, I believe, under 123A, allows in police reports and various other enumerated items. It does not enumerate a minimus. I suppose one would argue, and the Commonwealth will, that this particular record is admissible as assuming it's certified, as a certified record. However, it contains references within it that is totem pole hearsay.
Right, but what the Commonwealth says is that the totem pole part is cured by the fact that what it reflects is Mr. Connor's admission to the uncharged conduct. I think you'd be clearly correct that the uncharged conduct couldn't come in without that, but since it reflects his party, admission, that is a classic
Well, I give
hearsay
it,
exception. So if the document is admissible, there's an admission to the uncharged conduct. That, under normal rules of evidence, would also be admissible.
Right.
Where's the problem?
admissible, admitted to whom, though? This is a minimus. Again, the document itself has no indicia of any kind of reliability. It is not a police report. It is not grand jury minutes. It's not a signed statement. It is nothing more than an unsigned, typed note, I would suggest, that the police, after learning of this incident, recalled a similar incident at some point in time.
Well, this is appearing in a court record, so it would seem that this was brought to the attention of the juvenile court judge, who felt that this, and they apparently were transmitting to DYS some information about the juvenile they were sending to DYS custody, that this was done in court in some fashion. It's a court record.
I'll give you that.
Yeah,
It's a court record.
it's a court record.
How
well, that's why I asked to some. I mean, it's a court record. It's signed by, a magistrate. It's got a witness identified, and so on and so forth. But the question is, was there some kind of colloquy that, by which we can tell whether the defendant, in fact, adopted these statements?
Precisely, and we do not have that information. This was introduced to the trial court without the benefit of any of that information. Furthermore, a minimus is a piece of paper that's transmitted with the individual that is prepared after the trial or the plea or any court proceeding takes place. It is a matter of transmitting information to the holding facility. We have no way of knowing how this information was put on here, who put it there, or any way of any indicia of reliability whatsoever.
So explain to me how it hurt the defendant.
Well, clearly, there was a lot of evidence against this Mr. Connors. I can't argue that. However, the fact finder in this case, as I recall, this was a jury trial. So the jury would have been introduced not only evidence of those matters to which Mr. Connors had pled guilty. I believe in all cases he pled guilty, if I'm not mistaken, admitting his wrong, absolving himself, one could argue, certainly to a jury. And then they're presented with, well, not only that, he's done things that we don't even know about. He's done things that he hasn't even been charged with. For example, this digital rape. And so the inference to the jury, the prejudice, is tremendous to Mr. Connors. Not only is the jury presented with facts which are in and of themselves abhorrent, in which they would be perhaps prejudiced against Mr. Connors, but he could certainly argue through counsel that he absolved himself of his sins, as it were, that he acknowledged his wrong and he's paid his price and so forth. Here, we have evidence, uncorroborated, of outstanding crimes for which he has not been charged. In other words, the inference is clear. Mr. Connors not only has done things to which he has been charged and he has pled guilty and acknowledged, he's guilty of other things. It goes on forever. And I think the prejudice is rather overwhelming to a fact finder. And in this case, of course, it was a preserved objection.
Why is there no transcript of the plea at which these admissions were made? Because it was taped? And
Well, it's
the tapes-
1985, isn't it?
It was a long time ago.
I think there's- isn't there an
And
automatic-
I think it
Yeah.
was, whatever. And as I recall, the Commonwealth in their, at the trial and in their brief acknowledgments, the records of this particular plea don't exist,
Yeah.
for whatever reason. I don't know the answer to that, Judge. If I might touch briefly on the other issue that I have raised, and that is that Mr. Connors, excuse me, Mr. Connors was presented to the two qualified examiners, and he met with them and then declined to be interviewed pursuant to his statutory right. They then rendered an opinion within the 60-day period. He then retained, through funding, his own independent examiner and agreed to be interviewed by that individual. I don't think the interview ever took place because his examiner had passed away and they were looking for another one. But in any event, the issue rose before the court and it was preserved as to whether or not Mr. Connors would have a right to present his examiner, who would render an opinion based upon not only records but an interview with Mr. Connors.
Well, in this particular case, if you say he never did have an interview with his examiner, and it was, so there was never an issue, is it therefore moot? Is the question moot in this case?
I know his examiner passed away and that they were looking for a second examiner. I believe the record reflects that he was in fact interviewed by that first examiner. The way the issue was framed in the trial court, to my knowledge, is that the trial court was asked to decide whether it would permit Mr. Connors to present an examiner to testify on his behalf who had interviewed him while declining to be interviewed by the qualified examiner. The trial court said, you can do that only if you agree to be interviewed by the qualified examiner, or in the alternative, you can present your examiner without interview to match up against the qualified examiners who have not had an
Doesn't that
opportunity.
seem fair to begin with?
Well, I agree, Judge. Certainly, if you look at it on some sort of a balancing of fairness, you can't argue with that. However, the statutory scheme is set up that Section 9, as the court knows, specifically says that when the defendant places his mental status or his sexual dangerousness into play, that he will be interviewed. It's right in the statute. And if he isn't, the Commonwealth, if he refuses to be interviewed, the Commonwealth can move to dismiss, and there's some case law in that area. The issue with Section 12 is there's no statement with regard to interview. It merely says that the respondent will be examined, and it provides a 60-day period within which that exam is to take place. I offer to you that and Mr. Hirsch in his reply brief raises a point. If the requirement were merely for an interview, there's no need for 60 days. That can take place in a day or 2 days. It would seem that the legislative intent of this examination period is for the individual to be sent to the treatment center where they have experts and staff, for this individual to be viewed, for his records to be studied, perhaps for him to undertake, they do offer some classes, although it is limited to those who are held pre-trial, and then offer that information to the qualified examiner, who then will make an examination based on these findings for an opinion as to his sexual dangerousness. There's no requirement. And I see that I'm about to. Am I over my time?
You are, Mr. Fogarty.
Well, you tell me what to do.
Well, you can finish the sentence and then rest on your brief for your remaining arguments.
Thank you, Your Honors. I will rest then on my brief. My thrust of my argument with regard to the right not to be examined is the statutory scheme that is set up within Sections 9 and 12, which I think is made clear in my brief, and I would rest on that. Thank you, Your Honor.
Thank you, Mr. Fogarty. Ms. Grant?
Good morning. May it please the Court, Assistant District Attorney Cheryl Grant for Middlesex.
Ms. Grant, could I just ask you this question?
Yes.
On page 14 of the Commonwealth's brief, you say, this goes to the minimus question, towards the bottom. The Commonwealth argued, talking about why the minimus should be admitted, it said, where the respondent admitted to the conduct and the child identified the respondent. Are you talking about admitted to which conduct?
I'm referring to within the context of the minimus itself. It reflects that the respondent admitted to
But
the
we
uncharged
don't
act.
know if we don't have any record we have somebody saying that the respondent, but you don't have anything which shows that the respondent adopted that.
Correct. There's no additional records or a plea transcript. The plea was in 1985 in a juvenile proceeding, and presumably even if there had been original records, they would have likely been destroyed by this point.
My question is, how did this material get on the minimus?
Well, it's interesting. It just says circumstances, and so they're the circumstances explaining, correct?
Right. I mean, I would submit that there's an
But
official-
normally, suppose the defendant is convicted of first-degree murder. On the minimus, it doesn't say defendant assaulted his wife, stabbed her 10 times, and then admitted to the crime.
Right, I would submit that you could infer from this. It's on an official court transcript, and my reference being
No, it's not a transcript.
No, it's not a transcript. I mean, I don't understand.
The official
How did it
minimus.
get on there? Why is it on the minimus?
When I was referring to being a certified transcript, that's the definition of what a minimus is.
Well,
When you
that's
look
not
at
why
this-
it's on. Isn't it on there so that when somebody that's just been convicted of a crime goes to the jail will know how to deal with that person?
This was DYS.
Correct. This
Juvenile.
was DYS, and I do cite in my brief there's a couple of DYS regulations, and they also need to know how to classify this individual in results with the juvenile, how to treat this person. And I would submit that you could infer that that's why that that information is placed.
Here's
on
the problem. I take it, looking at Exhibit 8, that when you get to the third page, and I can just see the punch marks there, I don't have the actual document, that the circumstances of offense or offenses, must be a category, and then somebody types in the circumstances of the offenses.
That's what it appears to be on
Okay.
this sheet.
Now,
That's
the
on a-
offenses, however, presumably, as Justice Spina suggested, are to advise the receiving institution, this is somebody who has been, convicted of driving under the influence, or this is somebody who has been dealing drugs or whatever it is.
It may even
But
need
that's
protection.
that's on the other side of the minimus, because
Yeah.
what they've been convicted of is clear from the face. The crime is set forth on the other side.
What it
Correct.
doesn't tell
I mean,
you
all
the
they would have from that is the fact of whatever he was found delinquent of, and not the surrounding circumstances, which would
But the
certainly be relevant.
circumstances presumably normally would go to the circumstances of whatever it is that he's pleaded guilty to or been convicted of. Here we have additional information that's got nothing to do with the offenses.
Correct, I agree that it's not directly relevant to what he pled delinquent to, and that it's put in there in the context of that there were other circumstances that whomever drafted the certified minimus that went to DYS at the time found this to be relevant information that was
It may
important
be
to
relevant for that,
DYS.
but the question is, if you're describing the circumstances, I mean, I'm really concerned about going forward. Lots of the transcripts, in fact, all of the transcripts, to my knowledge, are likely to have been destroyed. And part of the problem with some of these proceedings is that you're going back to look at offenses that occurred quite a long time ago. If you're talking about the circumstances to which somebody pled guilty or was convicted, there you have at least some indicia that this defendant was either found by a fact finder or pled guilty to the offenses for which he has been convicted. When you start having information of other offenses for which he wasn't indicted, we don't know that he admitted to anything.
Well, I would refer the court to the Given case, which in Given, at that point, I would submit that you have more indicia of reliability here. You have an instance where the person's pled guilty, presumably this is after investigation has taken place, and they've pled guilty to certain offenses or delinquent to certain offenses in this instance, whereas in Given, it's in a police report, which typically is at a preliminary stage. And in Given, the individual, there was no indication whatsoever in the police report that that individual admitted to the facts of
Given
uncharged
specifically
conduct.
left this instance open. As
Correct.
You know, Given involved the statement of the victim as to what occurred, and at the same time she was raped, the child that was with her was also raped by the same person in the same fashion as part of the same act. So that is in fact one of the circumstances surrounding the crime to which she pled guilty. Ultimately, the crime against her, but that was one of the circumstances. This is not a circumstance having anything to do with the offense to which he's pled guilty.
Well, in Given, that also was an uncharged act within a police report, which is not expressly made admissible by the statute. The police report was.
The police report, but surely, I shouldn't say surely, in a footnote in Given, we specifically left open whether that reasoning would apply to an act which occurred at some other point in time that the victim was then talking about or the witness was then talking about.
Yes, I agree.
Very different. It's not a circumstance of the offense.
Well, it's in a footnote, but I refer to Given in terms of what the court looked at in terms of the reliability of the statement there.
And we don't know, here unfortunately we don't, there at least you have the police officer, you have it all in one report. Here we don't know, frankly, who typed this in, who told, in other words, this is not this police officer saying he admitted it to me. This is a clerical person. And it's not clear where the clerical person got the information from.
Correct. It's some type of clerical person at the conclusion of a proceedings where the individual pled delinquent to
It's still a
offenses.
court record.
Correct.
Could I just
Well,
ask
what a
you
court
one? Could I
record-
ask you one technical question, though?
Yes.
I know at times we have said that 14C makes admissible the things that are provided to the qualified examiner under 13B. But the technical wording of 14C makes admissible juvenile and adult court probation records.
Correct.
Whereas the qualified examiner gets all court records. What do we make of that? This is now, how is a minimus a court probation record?
That's why I would rely on the language in the Marquardt case, which I cite in my brief, because there are frequently, for whatever reason, differences between some of the language in 13 and 14, which in Marquardt, the Commonwealth tried to...
So you can see that this isn't a court probation record. I had the same question.
I agree that it's not a court probation, or it does not appear to be a court
so
probation
then
record.
it doesn't meet any of the requisites of the statute.
I would submit it does meet the requisites of Section 13, and the court held in Marquardt that in context 14C makes admissible all of the evidence that's required to be provided to the qualified examiners in 13, because in that case there were also differences between the police reports in Section 14, at least on the face of it, didn't use the same language that they used in Section 13.
Okay, but what in Section 13 makes this something that has to be provided to the qualified examiner?
It's a court record.
It
Just
says
simply
that-
because it's a court record.
It says the court shall supply to the qualified examiners copies of any juvenile and adult court records.
And was this supplied to the qualified examiner?
Yes. Yes, it was cited by Dr. Tolmich. He didn't rely heavily upon it, but it was certainly cited by him and mentioned, I believe once in his testimony. Dr. Kiley did not testify at trial regarding this incident, which leads into sort of my second argument that even if the court decides that even though it's in a court record, and I would submit it is reliable, at least certainly has some indicia of reliability where it is in a court record, and presume in reports that the respondent admitted to the acts and was identified by the victim, that in the overall circumstances of the case, that there was no prejudice suffered by the respondent, Mr. Connors, in this
But
case.
no, when you say she was identified by the victim, we don't even know who this victim was, do we? Or do we?
No, it just says that there was
No,
an
I
8-year-old
understand.
victim.
You're just repeating what's on the metamus.
Was this
Correct.
referred to in any police report?
No, I don't believe so. From my review of the record, this was the only instance, at least from the records that were introduced
Did
at
the
the trial.
Commonwealth use this in closing argument?
It was mentioned once in closing argument.
Why do you say there was no prejudice?
I would submit that the evidence in this case, regardless of this entry in the minimus, was extremely strong in this case. You had this individual that as a juvenile, in 1985, he pled delinquent in one plea to 2 separate instances of sexual conduct, including fairly pretty graphic factual scenarios where he sexually assaulted 2 young boys, I believe 7 and 9 or 6 and 8 at that time, and brought them out behind the building, held them at knife point.
No,
held
I
them-
understand that, but if you're looking at a pattern, if you listen to Mr. Fogarty's argument, he would say, you know, you have those two, you know, very serious, but the question, I assume, is, you know, is this part of a pattern, ongoing, unspecified number of instances, and that's, at least as I understood his argument, that's what makes this prejudicial.
But there were more incidents that were introduced.
Correct.
As I understand it.
You had an incident at one point when he was a juvenile. There was also another incident, indecent assault and battery, that he was also charged with assault with a dangerous weapon, again a knife. He was on probation for a separate offense. There were no police reports for that crime either, although they obviously had the certified juvenile records for that. And then within a month after that, so you had him on probation for larceny from a 10-year-old, and then a month after that, he indecently assaulted another child, under 14 was the charge. Unfortunately, we didn't have any of the facts regarding that incident other than what the charges were or what he was found delinquent for. A month after that, he then committed the offenses against the 2 young boys in Lowell, and then he was sent to DYS as a result of a plea, and within about 2 years after being out from DYS commitment, committed the governing offenses in this case, which were against 2 young girls whom he had befriended their mother and babysat them and repeatedly sexually assaulted them over a number of times, put dead mice in their underpants, and there were sadistic elements to that offense as well as the previous offense. So even without the reference to this, you had at least 5 separate victims over a course of 3 separate criminal incidents, both as a juvenile and as an adult. And the experts, when you read their testimony, Dr. Kiley didn't even refer to it at trial. It is mentioned in their reports, but really when you read Dr. Tomich's testimony, he really goes through his diagnosis and does not heavily rely on that, and is actually only mentioned toward the end of his testimony. And for that reason, I would submit that even if the court finds its error, that it's not prejudicial in the circumstances of this particular case.
Well, could I ask you, say that this was provided to the qualified examiners,
Yes.
and they reference both paragraphs, or I mean, it's the second paragraph that we're concerned
Correct,
about.
both paragraphs.
They make a reference to the second paragraph in their reports,
Yes.
and the one who testified made a reference to it in his testimony.
Yes, Dr. Tomich, I believe, did toward the end of his testimony. I do not believe Dr. Kiley actually mentioned it in his testimony before the jury, although it's sort of mentioned in Dr. Kiley's report as an historical fact, so it's certainly mentioned in both of their reports.
But the whole basis for all of that is simply the second paragraph of this minimus.
Correct, from
So-
my review of the records, yes.
So in the future, if we agree with you, it would be all right for an unknown person to scribble something on a minimus that refers to offenses with unnamed victims, and that could be used as a basis for some kind of decision.
You're talking about an instance where presumably you're talking about court officials who are acting in their duly appointed capacities within the court, and that they're only putting relevant information pursuant to their duties. I think you'd have to be assuming bad conduct or some type of...
Well, it would
on
seem to me,
behalf
at a
of
minimum,
someone.
we certainly could not allow this if it didn't reflect the respondent's admission to the offense, because then it would run into the same, it's uncharged conduct.
It'll be uncharged conduct, I think you'd have to look at the
Without any-
reliability of the
But
facts.
without, yeah, I mean, excuse me, a party admission is itself admissible.
Correct.
And here you claim to have that. Excuse me, if you didn't have that, I have a hard time conceiving of any theory on which this second paragraph could have come in.
Well, that would be, if it was an admissible document and under given, then the court applied the reliability test, which is where I would submit that you'd have to go through the factors, and I would submit that the circumstances of the entry certainly lend to that, and here you do have a purported admission of the respondent here. And I would refer the court to Given and in McCool for some of the language there, which I sent in a 16L letter for that, at least as sort of general overall support for that position. I see I have very little time. I don't know if the court has any questions. Maybe that would be the best way for the second argument with only short time.
Just rely on your brief.
Okay, I'll rely on my brief. Thank you, Your Honor.
Thank you, Ms. Grant.